Hello, everyone, and welcome to TDWI's webinar program. Thank you for joining us today. I'm Linda Briggs. I'm a contributing editor here at TDWI, and I'll be your moderator today. Our program today is Smart Data Discovery and Transparency for complying with CCPA, GDPR, and other privacy regulations. Our sponsor today is IOTahoe. And for our speaker, we have a single presentation from David Stodder with TDWI. So before I turn the stage over to Dave to get us started, just a few background items for the audience. First of all, our webinar today will be about an hour long. At the end of the presentation, Dave's going to throw the stage open to a question and answer period with audience members. So if at any time during the presentation you have a question for him, just type it in there on your console, send it over, and he'll get to as many of those as we can toward the end of the webinar. If you're a Twitter user and you'd like to discuss this webinar on Twitter, please include the hashtag TDWI. For technical difficulties, there is a help area on your slide window. You can click on that. Finally, for a copy of today's presentation, you can download a PDF immediately. There's a line for that on your console. In addition, as always, we're recording today's webinar, and we'll be sending each of you a link to the archive. I want to encourage you to pass that link on to colleagues as well if there's somebody who couldn't be here today but might enjoy this content. Okay, so once again, our program is Smart Data Discovery and Transparency for complying with CCPA, GDPR, and other privacy regulations. Our speaker today is David Stodder. Dave is Senior Director of Research for Business Intelligence here at TDWI. As an analyst, writer, and researcher, Dave has provided thought leadership on key topics in BI, analytics, IT, and information management for over 2 decades. Previously, he headed up his own independent firm and served as VP and Research Director with Ventana Research. He was the founding chief editor of Intelligent Enterprise, a major publication and media site dedicated to the BI and data warehousing community, and he served as editorial director there for 9 years. With TDWI Research, Dave focuses on providing research-based insight and best practices for organizations implementing BI, analytics, performance management, and related technologies and methods. So Dave, let me turn things over to you here.
Thank you very much, Linda, and welcome to everyone who's joining our webinar today. And thank you to IOTahoe for sponsoring the webinar. I think we've got something that sort of crosses over from our field of data management and analytics to public policy and so forth. So this is going to be an interesting topic, and I look forward to your questions. So my agenda, I will talk about just sort of broadly some trends in data privacy concerns, what the statutory response has been. So we'll spend some time talking about that. I think that's interesting stuff. And then talk about GDPR, which is really sort of the I guess, forerunner of all these kinds of privacy regulations. So it's important to look at that. And then look at CCPA, of course. That's what we're going to be talking about quite a bit today. And then talk about the data management considerations and how organizations can respond to the advance of CCPA and other kinds of regulations. I'll offer some recommendations at the end, and then I do have a poll question to get a sense of how our audience is looking at this, and then entertain your questions at the end. Okay, well, rising concerns about privacy. I think it'd be hard to be aware of news or current events at all today and not be thinking about the importance of data privacy. It really is coming up all the time, in lots of different ways. And so a lot of it is around the issue of trust. I think that's really sort of the basic issue when we think about it, trust between companies and consumers and customers, because companies are obviously, at least many, are amassing quite a bit of data about their customers, about consumers generally, about people coming to their websites, and there's increasing awareness of the fact that there's data that's being generated by all of this and that what's happening to that data. And so, some of it kind of ranges the reaction, of course, obviously from just hysteria that's not really informed to very informed response and concern and a lot of creative thinking about what can be done about this. But what's going on, there's a lot more data breaches. I think that obviously is getting people very anxious about the topic. It seems as though as much as many companies try to protect their data, there continue to be breaches. Cyber threats are everywhere. The consumers are also, as I mentioned, they're now more aware of all the data and the types of data that are being collected about their activity, and they don't like being blind to what is being done with the data. They want to have a better idea of what happens once they are clicking around a site, or once they have a transaction with an organization. What happens to all that data they generate? Is it being sold or shared? And is it being done so unfairly? There's this fear of the shared data. What happens next? Is it going to be stolen in terms of cyber attacks and so forth? Is it mangled? Could it be inaccurate? I mean, we've all encountered that, certainly, that data that organizations, whether private or public or governmental entities have, it could be inaccurate, and that's can present lots of difficulties going down the road, as many of us have probably experienced. And then the other bottom line of that is also just damage to reputations. I mean, it can go all around. Damage to people, customer reputations, and of course damage to corporate and business reputations if there are data breaches, if things are happening to the data that are untoward. And I put poor Mark Zuckerberg on the cover. Of course, he's not that poor, but he's certainly been a lot of the spotlight has been on what Facebook has been dealing with, kind of their behavior in the midst of all of this. But of course, it extends to lots of other companies. Here this graphic is interesting with Marriott. Because Marriott had a major attack, and then really just about every major company, it seems like, has had major attacks. So it's a high priority issue in organizations. And then of course the other side of it is that a lot of consumers are looking at what's going on and then going into hiding of sorts. They purposely falsify their data to protect themselves. They do things to avoid marketing. And so one of the things that's going to be sort of an issue is that a lot of the data is becoming less accurate. It's going to become more difficult to collect the data. Increasingly, this desire to be forgotten. Consumers trying to figure out how they can get off of the data train, so to speak. And so I think that's kind of an issue that the industry has to deal with too, is that people are going to not want to participate in this kind of situation. So the response, of course, has been a lot of stepped up legal and regulatory pressure. Here I see that I saw in the news that the U.S. Federal Trade Commission, they're seeing a rising number of enforcement actions regarding Internet privacy. So that right there tells you that there's a lot more concern at a governmental level, and also there's a lot more activity. So lots of enforcement actions trying to come after companies that are thought to be are violating Internet privacy kind of rules. And of course, the rules are coming up in all kinds of different states. We're going to be talking about California here, but Massachusetts has been very prominent. Vermont has been prominent. Colorado several years ago was on top of this. And then you really pretty much Alabama, other states around the country are really moving quickly to try to regulate the sale of data, regulate how companies protect privacy, to protect the data of consumers and customers. And what's happening is, of course, there's a growing momentum for a national privacy law, and actually it probably wouldn't be a bad idea because, with 50 states, it is already complex for organizations to try to deal with each state's different provisions. And so we are seeing already hearings at a national level. So I think that, I pretty much believe that we will have a national privacy law. I'm not sure when, but I would guess within the next 3 years probably. And so so I think that's some progress to watch. And of course, those national privacy laws will be based on what's happening at the state level. So it's important to watch that, not only because organizations need to comply with those laws, but also just to see what is likely to transpire at the national level. So this would reduce a lot of the confusion that is already occurring with all the different state laws. Of course, really, as I said, the forerunner of all this, there's a long history of privacy laws. So obviously GDPR, it itself was not the first. It actually built on, really 2 decades or more of privacy regulation, even predating the Internet, about what's happening with customer data and so forth. And then, of course, in the GDPR itself, there are lots of different regulations. And so in 2018, taking effect on May 15th, 2018, after being ratified about 2 years earlier, was the European Union's General Data Protection Regulation. And that was really the big topic in this field last year as organizations scrambled to meet the provisions by that deadline, and throughout 2018, trying to figure out where they're vulnerable and what they need to do to comply. And so it had a big influence, GDPR, on lots of companies, because actually companies, of course, have a lot of customers in the EU, and as I'll talk about in a second, it affected a lot of U.S. companies, obviously, because they do business in the EU. But it also had effect on the regulatory movements in Canada, Australia, Japan, China, and of course we're going to be talking about California here. So it's pretty widespread in terms of its impact. So organizations having to look at not only just how to comply with GDPR, but also how it's affecting other nationalities and so forth. So what it accomplished, as I was sort of alluding to, is it brought together the different 28 EU member states to agree on this one European Union approach. And this is why I think it's probably going to be replicated in the U.S., because within the EU there were lots of different regulations that, say, Germany had, France had, the UK had, and so forth. And so this is a way to put it all together and reduce some of the confusion about that. Of course, as GDPR goes forward, there's still confusion about how to comply with certain provisions of it, but at least they're not thinking about 28 different provisions. So it provided a set of regulations, and the key issues were how the data organizations capture the data, how they control the data once they've captured it, and then how they process personal information in terms of using that in their business processes, such as sales and marketing, and of course how they share it with third parties and things like that in the process, in the course of those processes. And as I mentioned, harmonize it across the U.S., and I think the U.S. is definitely taking note of this. I think that it's interesting. I saw this. It's very interesting on a site called helpnetsecurity.com, and this kind of summarized an organization called RedScan did a Freedom of Information Act in the UK so that they could analyze 182 reports that were made to the UK's Information Commissioner's Office, which looks after data privacy, among other things. And so this was in the kind of the year before GDPR was enacted, and it gives, I think, a good summary of some of the issues that came, pushed for, made GDPR necessary, in other words. And some were around delays. You can see here delays in reporting breaches to the ICO, so privacy breaches, attacks where data was stolen, and so forth, typically between 21 and 142 days. Well, GDPR has a required reporting limit, reporting within 72 hours. So you can see there where companies are under such pressure. The amount of time in reporting the breach was clearly too long, but they have to really make a lot of changes to be able to report it within that 72-hour window before they get penalized. Failure to include important information about the impact of the breach and the length of the recovery process. So a lot of details were not known, at least to the ICU for sure, and in many cases organizations didn't know themselves. They were sort of catching up as it went forward, so didn't know what was the impact, what kind of data was affected, how much data. They didn't know how long it was going to take to recover, and so a lot of knowledge not known there. Of course, GDPR comes down and is very specific about recovery process, how long they need to take, being able to be on top of the breach, what data was affected, and so forth. Less than 25% of businesses would be GDPR compliant as of April 2018, so that's a month before it goes into effect. So that's quite astounding in itself, and we saw in our research as well that U.S. companies were even less than that. It was under 20% of U.S. companies were ready for it as of last May. We haven't really seen how they're doing up till now. Hopefully, they're much better off now. Most companies lack the skills, technology, and procedure to detect and handle breaches. And so this is a big issue in organizations, is they really need to step up the skills, hire professionals, privacy and data protection professionals, It's again becoming difficult because there are not as many out there as organizations need to revamp their technology and procedures so that they're really prepared to detect and handle these breaches quickly, be able to report on them to GDPR organizations or ICO and that kind of organization. And it's difficult, obviously often data breaches are very subtle, purposely, by the hackers and the attackers to make it difficult to detect until data is stolen. So it can be like finding a needle in a haystack, as one person said. And then the other thing that's interesting, I think, just for organizations to think about is that most data breaches happen on a weekend. So obviously looking for where an organization's guard may be down or maybe where they're doing procedures and, they're not paying attention. So focusing the mind. Stiff penalties. I mean, the penalties are what get a lot of the attention, and GDPRs are onerous, and we'll see that CCPAs are not small either. So there are fines for not reporting personal data breaches within 72 hours or for concealing it. Penalties can be up to 4% of global annual revenues, up to, I think, in U.S. equivalent, about $24 million. So it can be a significant penalty. And then the cost of compliance itself, of course, organizations are looking at that, which is more costly, complying with this or enduring the fines. And I think that probably it leans on the cost of complying is a better deal, and plus there's the reputation issues and all that I discussed before that are critical. But here we have PricewaterhouseCoopers survey that finds most companies expect to spend between $1 million and $10 million to meet GDPR requirements. So it's something organizations can't do in a small way. They have to really think about it and build an significant strategy. So yeah, it means that organizations cannot be passive. They need to be doing all these things. They need to be anticipating data breaches. They need to improve their ability to discover data breaches and discover what data was affected. They need to be able to report on it, so step up their ability to report on how they're doing in terms of protecting the data. They need to remedy the data breaches as quickly as possible and within the limits that are required by the statutes. And so all this must become part of this up. And we do see in our research broadly, we've seen the title of the Chief Data Officer beginning to increase in organizations. And one of the first things that seems to be landing on the Chief Data Officer's desk or list of their priorities is governance. And so governance often around adhering to regulations. Another title that an organization is rising is, of course, Chief Privacy Officer. So sometimes these are all kind of melded together or have different kind of titles depending on the organization. But the point is that in many organizations, they're seeing they really need one chief officer who is on top of the governance, about the protection of the data, understanding how their conduct with the data comports with the regulations such as GDPR or CCPA. So that's something that I think organizations need to be thinking about. It could fall to the CIO. The CIO has a lot of different duties that they have to take care of, and so it could be a good idea for them to delegate this to a chief data officer, a chief privacy officer, or somebody in the organization who can be on top of this. Organizational reputation is at stake. I think, I sort of mentioned that earlier, but I think that's another thing that is a reason why organizations can't be passive about it, because the public, remembers. They remember what happens to organizations, they remember these breaches. It makes it difficult for them to do business with them. And then attention on privacy, it's going to force changes. I think it really is one of the real change agents as we move forward in organizations. There's been a long stretch where they haven't had to really focus on it. So now I think organizations really need to be thinking about privacy from their earliest levels of maturity with data systems in terms of how they begin to collect data, how they process it. So it's not something just for more advanced use, but really should be thinking about it early on in projects and in processes. So, that's how the kind of internally, but GDPR and I think some of the other regulations also are specific about assigning accountability for guarding the data and who are the participants, because obviously if you're talking about sort of in the legal sense, they have to begin to define this. And so GDPR does this with the idea of the data controller as the entity who determines the purposes and meaning of processing the data processors, the entity who processes the personal data on behalf of the controller, so different parties and those who are accountable. And then they really prescribe that organizations need to assign a data protection officer. What I mentioned here, the controllers and processes can be held liable. So that's what I'm talking about in terms of the legal responsibilities for data breaches and noncompliance. And then it also, the organization needs to assign a data protection officer. It could be someone with another title, or it could be someone with that specific title, requires the controller and processor to designate this person if they process data and store in EU citizen data. So that's one thing to think about also with these regulations is the legal definition of responsibility and accountability, and making sure that you're responding to those requirements. Okay, let's talk about CCPA specifically and what it is. First of all, it's the California Consumer Privacy Act. It will become law on January 1st, 2020. It was enacted in June 2018. So in a sense, we're kind of in that period that organizations were in before GDPR was enacted, where organizations need to be moving towards compliance and being prepared to comply as of January 1st. Now, of course, what makes it difficult is that a lot of these regulations, and CCPA is no different, is still being revised and amended. So in my research looking at it, SB 561 is the one to watch for. There are probably others that are going to be coming up that are important. So this will be amending it, and is in the process of being amended. I think there was an amendment last September. There's other amendments that are still being worked on now. But the main drift of it, of course, is really to impose even stiffer penalties and protections. So that's one thing to keep in mind, is that's what the direction of the amendments and revisions are really towards. It's about protecting California customers. It affects, therefore, California-based for-profit companies. So it focuses on for-profit companies, whereas GDPR was all organizations. And for those who are doing business with customers and consumers in California. So if by some reason your company is not doing business in California, you may not need to worry about this, but I think most companies probably are doing business with customers in California. It was definitely inspired by GDPR. There's very similarities, but some important differences as well. And it's also based on a long history of California laws around privacy that date back decades. And so just to quote sort of the fundamental idea, the fundamentals of the right of privacy is the ability of individuals to control the use, including the sale of their personal information. So we can see that sort of boils it down to what is the driving strategy of this initiative. So the scope is big. As I mentioned, most companies do have customers in California. It would be hard not to. California has 40 million residents, or just about 40 million residents. As I mentioned, it applies to for-profit companies. So at least for the moment, it's not including nonprofits. It applies to companies with revenues of 25 million or more. For those that are holding data generated by 50,000 California-based consumers, households, or devices. And that's a pretty small number if you compare it to 40 million, so that's not that many in many ways. And it also applies to companies that are deriving 50% or more of their annual revenues from selling consumers' personal information, so that's something to assess in organizations. One other important provision in it is it has this 12-month look back. So again, this puts the stress on what organizations right now to be able to account for and report on what's going on with personal information, their PI. So they need to report on the records of PI dating from January 1st, 2019, so the beginning of this year. And so that's important to remember. Really, the clock is already ticking on all of this. And then, as an example, one that I pick up, if you think of a restaurant chain, often they don't realize how much data they're collecting and the responsibility for it. So a chain might be collecting data via their point-of-sale systems. If customers coming in, we're sitting there using their Wi-Fi in terms of mobile systems, maybe they're collecting data there. Lots of different ways that organizations collect data that may not necessarily be obvious. And so they need to look at how they're collecting and managing that data, whether they're selling that data, to third parties or to other partners and so forth. Be able to track that data, track what has changed in that data, or at least what has changed in terms of their sale of that information, and they have to be able to monitor the data, how it's sold or disclosed to third parties. So all of this is really happening right. Organizations should be paying attention to this right now, as I mentioned, so particularly with this 12-month look-back provision. So one thing to think about is, what is defined as personal information, and GDPR and CCPA define them both. I could read them. I know there's a lot of words on a slide here, but so basically, GDPR defines any info relating to identified. I guess my main point here is it's incredibly broad. There can be a lot of information that be considered personal information, and it's a definition that is a little bit, there's still always a lot of movement. So it's important to think about it. So any information related to identified or identifiable natural person, particularly by reference to identifiers such as name, identification number, location, and A data, online identifiers, so including emails, things like that, to one more specific to the physical, lots of different conditions, physiological, genetic, mental, all these categories and conditions of that person. CCPA sort of picks up on that and boils it down to information that identifies, relates to, describes, or is capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. So as you get into it, there's actually an enormous list of possible types of data that could be identifiable. And so this is a challenge in organizations as well as they begin to look at different attributes they collect as they do marketing segmentation and so forth, and look at those different kinds of attributes. Those all can boil into up to being identifiable, so it could be personal information. So be looking at all the different connections of the data. And then many possible identifiers around location and things like that. They include things like IP addresses, browsing history, inferences drawn from any of the identified information. That creates a profile here. I'm quoting this site, blackpoint-it.com. Had some good information about this. So this is, I think, one of the challenges in itself of working with personal information, adhering to the regulations, is the very expansive definitions of what is personal information. So some of the important provisions, the key things that the CCPA covers, number one is the right to know. So customers will have a right to know and be able to access their personal information, personally identifiable information. I use the PII definition here. They can do it once a year and for free. Companies have to tell California citizens what categories of information they have collected on you, your devices, and your children, so the whole household. And as I mentioned before, there's lots of different categories of information, so it could fall into a lot of different areas. They have a right to know about the sale and disclosure of the data. So if a business sells your information, the customer has a right to see what it was and to tell you what categories of information, or the company needs to tell you what they've been selling and to whom. And then, of course, the other side is that customers and consumers have a right to say no. They have a right to tell the company that they cannot sell their personal information. They can opt out. And one thing that's important here is that GDPR uses the idea of an opt-in. So they're, and I'm sure everyone experienced this, constantly getting this affirmative action from consumers to lots of emails that we all got asking us to opt in. This was the mechanism that was used to bring about a deliberate action, in other words, to opt in. The California statute uses the idea of opt-out. So you have to actually inform the company that you want to opt out of the system. So it's a little bit of a different way it's done. That's actually an important consideration. Of course, those who are under 16 need written opt-in. So data about consumers who are under 16, gamers and so forth, it can't be just done and wait for them to opt out. It has to actually use that mechanism with an email or some sort of way of making sure that they opt in. And then here's the other conditions. Businesses do not have to comply with the request for deletion, in other words, the no, if there's a need to maintain the data in order to complete a transaction, to maintain adequate cybersecurity, to repair service functionality errors, exercise of free speech, or comply with California Electronic Communications Privacy Act, So there was some legacy around other kinds of statutes. And so, again, more complexity around what actually people have to have the power to opt out of. Another condition that's important is equal service and price. So if a California citizen does opt out, they do say no, company cannot charge them more or offer less services or things like that just because they did that. But at the same time, the provision does allow for organizations to offer incentives to gain that opt-in from customers or consumers. So that is allowed. So some of the penalties and provisions. So here it's up to it was written to be up to the California Attorney General. And so what this has meant was that the Attorney General, first of all, had to inform the organization that they were going to be, that there was an issue. But that's become impractical because obviously there's thousands of companies. It would be impossible to do it. So this is something that is being revised in the current bill that will make it so that the Attorney General really just needs to give a general guidance via publication. And it also is most likely going to take away the 30-day remediation period. So the the Attorney General would inform the company. They'd be given 30 days to remediate, to make amends and fix the problem. Now it's going to be general guidance via publication, and the Attorney General can enforce without prior warning. So that's something to be keeping in mind too. That even more incentive to be adhering right away. Civil penalties for each violation, up to $7,500 for each infraction. And so if there's 10,000 customers, that can equal 75 million. So that, in other words, it can add up quickly. It's big. And also the other thing that's being revised in the latest bill is that it will open up the idea of a private right to action, whereas before there was no provision that a customer, for example, could sue. Now that appears to be moving in the direction where it will allow for a permission to sue for violations and to recover damages. Again, lots of possible penalties. So some of the personal information considerations for a CCPA that, in other words, the questions that really need to be answered by organizations as they look at how they manage this data. First question is, what personal information do we have? What is it being collected and stored, and for what is the purpose? I think that's one thing we may see as a trend in organizations. I've seen it some with GDPR is really questioning why an organization is storing certain data. Maybe there's too much liability or too much risk involved in storing it. And so I think whereas organizations have been wanting to collect as much data as they possibly could in the event that they could analyze it or would have a reason for it, the thinking on that may be beginning to change. So what personal information to have and store and for what purposes? And then, of course, is it secure and well-governed? That's, of course, the key question. What categories of personal information are being collected, shared, and sold? So as I mentioned, a lot of marketing kind of scenarios with segmentation, getting more fine and using more detailed data, different combinations of data. It's becoming, there's lots of different types of categories that are based on different kinds of activities, different behavior of a customer, where they're coming in from in terms of the channel, whether it be a mobile channel or physical brick and mortar kind of store channel, that kind of thing. So lots of different information. So organizations need to understand what the categories are, because it appears that in CCPA a lot of those categories will be covered as personal information. The status of the communication with customers and consumers about opt-out privileges. So there have to be good records and reports about where that stands, and of course that is key to honoring those agreements that they have with customers and consumers, and making sure that those are honored as organizations work with third parties and share data. Preparation for adherence and expected revisions to the statutes. So this is another consideration. As I mentioned, all these statutes are kind of moving all the time and evolving and being amended and so forth. And so it's important to be able to have a posture where you can handle those revisions, which requires some agility and flexibility. So really the first question all this, as I mentioned, to know what data is being collected and stored and for what purpose, first question is where is it? And I think in That's not an easy question to answer for most organizations, as they have lots of different data silos, different diverse platforms, organizations moving into the cloud, so they have some data on-premise, some data in the cloud. And what they need to do, and this is a GDPR provision for sure, and is really important to comply with CCPA, is to get an inventory of that personal information and get a complete view of the customer and consumer data. So this is, again, something that will change how organizations think about how they manage this data. Metadata is definitely useful for finding this personal information. So a lot of organizations are leaning on the use of metadata and improving their data cataloging, where they often manage metadata. But they often still need to look at the detailed data. But here I mentioned that metadata is useful to really get the inferences, to be able to draw inferences around different types of the categories of information to create that profile of the consumer that is certainly being used in marketing and sales and so forth. So now it needs to be used to protect that data as they begin to sort of understand all the different kind of attributes and types and categories of data that could be personally identifiable information. And really the key, I think, technology and process and practice is around data discovery. So to build that inventory, you've got to be able to locate the data, understand data relationships, those inferences, how the data relates in terms of its categories. And so data discovery technology and data discovery practices are going to be critical to build that kind of awareness, to build that inventory. In many organizations, unfortunately, data discovery has been pretty ad hoc. It's usually left up to the departments, or maybe IT is doing it, but for only certain data platforms that they've got. There's a lot of manual work that's done. Sometimes that manual work is even farmed out, so it's not even done in-house to discover this data. And most organizations are discovering this really difficult to scale this up or keep up with the requirements, which are getting more onerous. So organizations need to discover if there are vulnerabilities, if the data is could be, there could be breaches and the data is not being protected carefully. So again, a lot of different platforms, as I mentioned. There's cloud, there's on-premises data warehouses, and also don't forget the data marts, BI and OLAP data marts, and other kinds of specialized data stores that are being set up. And then, of course, there's application databases around OLTP, web, e-commerce, and so forth. And another area that's often overlooked in organizations where there could be personally identifiable information is in develop and test environments, as, of course, there are many of those around, and often databases built up to serve those that are not well tended, often are not protected very carefully because they're kind of develop and test environments. Well, now that could be a vulnerability. So key technology that can be used in discovery is to get a quick search. Often concept search is useful because you're looking for, again, those connections, those data relationships. So it needs sort of a bigger idea of what this kind of personal information is. So capture those relevant relationships and discover all these different attributes and differences, and then see the differences in how the data has been recorded. Well, I guess my point is here is that often as we discover in data quality procedures and data profiling and so forth, how often the data is recorded differently, maybe about the same person. So concept search and, of course, other kind of data profiling and quality techniques can be very valuable in bringing this kinds of information together and start to see, oh, okay, this is about the same person or same household coming from the same device and that kind of thing. And also discovery is useful for discovering data ownership, so beginning to understand who is responsible for this data and beginning to work at it from that direction to work with the data owners. Often it could be line of business or subject matter experts who are sourcing this data to begin to work with them to protect the data and make sure they're aware of the regulations. Now, what's happening, of course, in the technology direction is, like with everything else, is AI and machine learning is becoming critical to improving discovery and improving the ability to search for this data and do it quickly and at scale. So we're seeing a lot of solutions in the industry looking at or adopting AI and machine learning technologies for data discovery, for populating data catalogs. A lot of the data cataloging or technologies solutions out there that offer data catalogs are now embedding machine learning, again, for the idea of scale and to be able to find different types of data. And of course, one of the great things about, different types of data into the volume and also streaming data as organizations begin to collect that sort of data. But one of the best things about machine learning is the idea of the unbiased examination. So it can look through, it's just letting the data speak, in other words, and beginning to formulate an understanding of data relationships, of course, other things too, trends and so forth, predictive trends. But here we're really talking about trying to locate the data and build an understanding of the relationships. So using the algorithms and statistical methods and models without the explicit instructions that are necessary, in other words, so that the machine learning can be used for examination on the kind of scale and letting the data speak for itself in suspect. And so these technologies are critical to underlying governance. So the privacy, data protection, governance is sort of part of all of that, not necessarily always on top of it. As I mentioned, in organizations there could be different ways it's structured, but governance rules and policies need to address CCPA and other kinds of regulations so that it's addressing how users in the organization collect data, how they source it, and how they share the data, and what they do in terms of transformation and other kinds of enrichment kind of activities, that they're aware of the policies and that the opt-ins and so forth or opt-outs are followed as the data moves through its life cycle in the organization. Data discovery is critical to learning about and documenting data lineage. And so we certainly at TDWI have been talking a lot about the importance of that, to study data lineage so that data can be well governed, also data lineage so that organizations can track back analytics to understand where the data came from, what was done with it, to interpret analytics better. Well, here we see it for applying to regulatory adherence. So GDPR has this idea of the right to an explanation from analytics, basically so that the consumer can understand why they may have been denied a loan or something like that. Organizations need to be able to explain that to the consumer, explain the analytics that went behind it. So, there you can see sort of the regulatory pressure to establish data lineage. But even here, data lineage can be very useful to understand sourcing of the data, how the different pieces of data were combined, so that, again, it can be the privacy issues can be monitored. And then governance and auditing over time. Again, this is not a static situation. Of course, organizations are obviously collecting new data all the time, and so governance needs to apply to all the new data, how the data is being changed. And so, again, that kind of oversight of how of monitoring PI data changes and this flow through the organization, and also making sure the adherence is constant, so that it isn't done something once and then kind of neglected over time. So this is critical. And also, as a last thing here, monitoring use of self-service BI and analytics, as I mentioned before, organizations are becoming more diverse in terms of how users work with the data, which is great. But governance needs to balance that out with monitoring capability so that everyone understands what's being done, particularly with the personal information as organizations move into more self-service analytics. So what's needed then is an ability to meet compliance reporting and auditing requirements. And so organizations are going to need to set up a lot of different kinds of reporting and constant reporting. So it's not something really done once a year. There may be some provisions that are only needed once a year, but it needs to be a constant effort to be able to respond to audits, to make sure that the processes of what they're doing with the data are auditable. They need visibility into the data so they can monitor the status. So discovery tools and solutions, the discovery procedures need to have good data visualization, and so that organizations can constantly be seeing that through dashboards and so forth. There has to be a lot of risk monitoring and reduction. So look again, a lot of with GDPR and CCPA, it's about a risk-based approach, like looking where are the vulnerabilities, where could we have issues here, and so organizations need to be thinking about that, where there could be vulnerabilities, and monitoring those always and reducing them. And then, of course, handling consumer rights requests. This has got to be a high priority to make sure that opt-out is honored continuously throughout their different processes, where the sales, marketing, and other processes. So it has to be sort of a capability for doing that, usually through reporting and auditing. Okay, well, I'm going to offer some recommendations, and then we'll sort of move to your questions. We've got a poll question coming up. So the recommendations, first is to understand the CCPA requirements. I've tried to give you a pretty good kind of overview of what they are and the main provisions of it in terms of the right to, for Californians to know what information is being collected, what's being sold, their right to access that information, their right to understand that they can say no, they can opt out, and then the fact that they cannot be denied equal service and price even if they exercise these privacy rights. So those are the key provisions, but of course there's obviously a lot of detail behind that, so it's important to understand that. And that this effort should be headed up by a chief data officer, a chief privacy officer, chief data protection officer. I would say we would advise at TDWI to put that, centralize that authority and that responsibility in the organization. Now, of course, as I mentioned before, GDPR and some of the others have specific kind of areas of responsibility from a legal sense, so make sure that those are addressed as well. Align governance policies with the statutes, so make sure that this is all happening with an understanding from the governance committees or the whatever the organization does in terms of handling governance, and look for overlaps because obviously there's GDPR, but there's also HIPAA and other kinds of industry regulations that are about privacy and protecting personal identifiable information. So look for where the overlaps are to avoid redundancy and make it a more streamlined effort. Take this risk-based approach, which basically means find and mitigate the data vulnerabilities. So don't be passive about it. As I mentioned, organizations need to step up and take an active posture in this and look for where there could be vulnerabilities. Establish how you will deal with requests. So there are going to be a lot of them in terms of California's, the CCPA request to say no, opt out. So there's going to be this kind of interaction with customers and consumers that needs to be easily dealt with in organizations and honored as time goes by. So honor the CCPA principles in business processes. So these, again, the right to know, the right to notification, to say no and to opt out, and then the non-discrimination. So with data discovery, definitely improving data discovery. I think this has got to be a priority. In many cases, it is a priority in organizations as they're doing business intelligence and analytics. Data discovery is important, but now we're talking about really data discovery as part of data management and as part of knowing about the data and being able to monitor and govern it properly. And so now there's regulatory pressure to make sure that this sort of data discovery is effective in organizations. Definitely want to evaluate the newer technologies that are using AI and particularly machine learning. They're AI and machine learning driven technologies that can scale to the data volume, can handle the kind of data complexity in terms of particularly all the different categories that are part of the PI picture, and be able to locate and manage this data and look at all the different kinds of sources in terms of indexes and so forth that could be valuable for finding this data and metadata. Plan for ongoing discovery throughout data life cycles. So this is not a one and done. This is something that's got to be monitored throughout the life cycle in organizations. Improve data cataloging. So data discovery is important, but also data cataloging can be very valuable in terms of collecting the metadata. And as we've seen, there's lots of good tools out there that are using AI and machine learning to improve the generation of that data catalog to gather the metadata. Well, a lot of this, of course, used to be manual and kind of done in an ad hoc way. The AI and machine learning can help organizations scale up and do it in more consistent fashion. And then, of course, using search effectively to discover and document data similarities and relationships is valuable. And then finally, be prepared for change. If we did this webinar in a year from now, of course, that'd be very interesting because CCPA would be in effect, and we could see how organizations are doing with that. Years go by quickly, and so there's still regulations and statutes that are evolving as they're being amended. As I mentioned, that one that we'll probably see an amendment at some point this year. Okay, well, thank you very much. That concludes my presentation. And Linda, I think we're going to do a poll question to see so we're asking here, how far along is your organization on its journey toward compliance with data privacy regulations such as CCPA and GDPR? So sure, there's some out there who are fully prepared to comply. So we'll see what the percentage is there. Second category, we have a plan and can locate most personal information, but we need better technology skills and practices to complete our compliance. So we're seeing that often, that organizations feel like they can find it, but they can't. They lack the modern technology to handle it. So the third category would be, we can comply for some of our data, but do not know where all the PI exists yet. So they're just beginning to get. And then the fourth category would be, we're just getting started and are hitting challenges, and then finally don't know or not applicable. Okay, well, let's see what the results are. And great, so we actually almost 9% are feeling that they're fully prepared to comply. That's excellent. I think that those are going to be leaders in compliance for sure. Now we see that, let's see, yep, actually 27.3% here saying that they have a plan, so that's good, and they can locate most of the PI, but then they need better technology and skills. So those are important. So look for good solutions and revising practices to complete compliance. 18.2% saying that they can comply for some of their data, and we do find in our research organizations are often confident that they can govern the data warehouse, for example, but they can't govern the data lake and other kinds of application databases and so forth. And so that could be the case here. They can comply with some of the data, but not know where all their PI exists yet. And then we have 18.2% just getting started and are hitting challenges, no doubt. You have a lot of company there, at least, with 18.2%. And then finally, 27.3% don't know or are not applicable. And it could be based on the provisions that we have here. Other companies don't follow those categories. Okay, well, Linda, I think we won't have an IO toggle presentation, so we're going to go directly to questions today.
Okay, yeah, sounds good, Dave. Let's jump into answering some of these. We do have some interesting questions. I'm going to start with one to clarify a slide that you put up earlier when you were talking about the size and scope of, get that up there, of the CCPA. The question here is someone asking to clarify. So does that apply to companies that meet all three of the criteria you have listed there, the 50,000 customers and 50% revenue from selling data and $25 million in revenue, or is it just any one of those?
Boy, that's a good question. I think it's any one of those. That would be my reading of the CCPA, but I don't want to be. I'm not absolutely positive. So I think that's probably a question I need to check on. But the way I thought that it was worded was that if you fell into any one of these categories, your company applies.
Okay, I'll send this to you after the fact so you can follow up. Let's go with another question here. This is a good basic question. What are some of the first steps we should take to protect data and adhere to the CCPA?
Well, I think, as I mentioned, the first step really with GDPR was data inventory. And I think that applies well to CCPA as well. The first thing is, what do we have? Where is the data? How are we collecting the personal information? So, and that's a big question. So it's not something that can be answered quickly. Usually in organizations, it's going to take a while to get a good answer to that question. So that's where I think data discovery is often very important, is because that can help you begin to find that data. And so I think that's obviously the first step, is to just sort of find the data, find where it's being sourced from, and so you can kind of get a handle on that. That would be the first consideration. And so it often could be in an obvious place. It could be the databases or data warehouses that are handling marketing and sales, where there's a lot of customer interaction. Of course, with companies doing a lot of social media, you have to think about that as well. If there's collecting any kind of data around that could be very important. as I mentioned, I thought it was interesting, the restaurant example of point of sale data. That's a kind of application, OLTP sort of data where there can be information being collected. And then as organizations, physical organizations like that have Wi-Fi, they're collecting data there too. So think about areas where you may not be obvious. Kind of marketing and sales databases are obvious, but there could be other areas where data is being collected that are less obvious.
Yeah, interesting. Here's kind of a philosophical question a little bit. Someone's asking, do you see the U.S. moving in the direction of adopting the GDPR or regulations like that?
Well, I think, the U.S. is going to do it their own way, but I think the U.S. has people studying GDPR, or has ever since it evolved and became law. And I think if you listen to the debates in Congress and so forth, GDPR is top of mind. And so I think that probably the national privacy law will resemble GDPR. I would not be at all surprised at that. But at the same time, the CCPA has some differences about it that, it depends on how you want to interpret it. I think that so there are differences in terms of, some might say some provisions are more friendly to businesses, although with the amendments, I'm not sure that's going to be true, that they can be pretty hard on businesses that are not complying. And in some ways, and I think in terms of the penalties, I think they're both, penalties are significant. And in terms of the timeliness, they're very similar. So in terms of how fast organizations need to respond to breaches and be able to report on them and so forth. So those areas are similarities. So I think the answer probably is that GDPR is very influential. It's influenced CCPA. CCPA does have some differences, and of course there are other states, Massachusetts and so forth, that are kind of more about the data brokers, kind of trying to regulate kind of that marketplace about data more than they are about privacy protection. So I'm sure all this is going to get thrown into consideration for a national privacy law. I would guess in the end that it will probably resemble GDPR, though.
Yeah, I'm wondering as well if the CCPA, California, may have quite an effect on the rest of the country.
It certainly will. I mean, as I had the slide earlier about the size and scope, I mean, California and the California economy is enormous, and so it certainly will affect, I think, the rest of the country.
Right. Heading in another direction, here's an interesting question. We're having difficulty tracking customer data because we have multiple sales and marketing channels. Would you suggest that we centralize this data in a data warehouse for governance? Well,
I think that is definitely an option. And we've seen organizations actually, we asked that in some of our research earlier, as I mentioned, the organizations are more confident in their ability to govern the data warehouse. So that might make some sense to centralize personal information. Now that's easier said than done. As I mentioned before, there's personal information everywhere, and so you're talking about probably more like a data lake that could take lots of different kinds of information and put it in the same place, and then find a way to have sort of perimeter, data security to guard its use, and then the ability to protect that data as it's flowing and as it's into the system as a consideration. Then, of course, what happens to the data then in terms of transformations and what people do with the data. So it's more complicated than just thinking about centralizing the data. But I think that could be an option depending on what the organization's platforms are now, where they're headed with those in terms of maybe moving into the cloud, in terms of like a big cloud data lake, that kind of thing. I don't know if I'm giving you a very clear answer. I think it's easier said than done. It could be the organization will look at this and realize that it's not possible, and they're going to need to use discovery technology, use the kind of AI machine learning driven discovery capabilities to find that data and monitor it where it lies rather than centralize it. They may centralize as much as they can, but understanding that there's always going to be data in diverse systems, because that's just the way it is.
Right, right. All right. On that note, Dave, we're just about at the top of the hour, so thank you again. That was Dave Stodder with TDWI. Again, thank you to IO Tahoe for sponsoring today's webinar. We very much appreciate that. I want to remind everyone that we did record it, and we'll be sending each of you an email with a link to the archived version of the presentation. And please feel free to pass that along to colleagues who may not have been able to make it today. I'm going to pass questions that we didn't get to on to Dave so he can follow up with you afterward if he has a chance. And finally, I want to remind everyone that TDWI offers a wealth of information, including the latest research, reports, webinars, and information on business intelligence, data warehousing, and a host of related topics. I encourage all of you to tap into that expertise. It's at tdwi.org. And on that note, from all of us here at TDWI, thank you very much for attending. This concludes today's event.